The U.S. Department of State released its Visa Bulletin for February 2023. We saw no changes in the final action dates for the major employment-based visa preferences. So for today's video, I'll run briefly through the current final action dates, but then I want to highlight a recent proposal for rulemaking by USCIS to raise fees for all visa applications and what impact this could have in the near future. For EB1, final action dates remained at February 1st, 2022 for both India and China. These dates were initially set in January when this preference had been current for all of last year. For EB2, final action dates remained at June 8th, 2019 for China and October 8th, 2011 for India. Notably, the rest of the world have final action dates now, which will further extend the backlog for China and India. For EB3, final action dates are still August 1st, 2018 for China and June 15, 2012 for India. No improvement there. For employment-based third preference, other workers, we're now seeing a retrogression worldwide for this category with a final action date of January 1st, 2020. For EB5 investors from China and India are still facing backlogs. China's final action date is set at March 22nd, 2015, while India is set at November 8th, 2019. For those that filed prior to March 15, 2022 that are from China and India are experiencing retrogression. This does not apply to new EB5 investors filing after March 15, 2022 in the new visa set-aside categories. These visas are reserved for investors that make qualified EB5 investments in rural, high unemployment area, or infrastructure projects. Investors whose priority dates are current under the February Visa Bulletin may file their adjustment of status applications. And for new EB5 investors already in the United States on a valid visa status may file their adjustment of status application concurrently with their EB5 petition. Typically, your lawyers will be able to prepare your EB5 visa petition, I-45 adjustment of status application, EAD, and advanced parole forms in about 2 to 3 weeks once you've decided to go forward with EB5. This means that you can get your work authorization in about 3 months. Learn more about this concurrent filing strategy in our deep dive video here. Recently, on January 4th, 2023, USCIS published a notice for rulemaking to raise fees. There is a 60-day notice and comment period to enable the public to review the proposed rule and submit comments. This closes on March 6, 2023. I'll put a link in the description below to the proposed rule. So what's being proposed? USCIS claims it cannot keep pace with the current workload under its current budget and staffing levels. So it seeks to raise fees charged for all visa applications, while exempting fees for various humanitarian programs, including asylum applications. For the EB5 investor visa, USCIS proposes the largest increases. For example, the I-526E petition, which is the initial EB5 petition, the current fee is $3,675. Now, under the proposed rule, the fee will increase to about $11,160 per petition. That's a 204% increase. Likewise, the I-829 petition to remove conditions and receive the permanent green card, which is the last stage in the EB5 process, fees will increase from $3,835 per applicant to $9,525. That's a 154% increase. EB5 regional centers are not exempt from these increases either. Regional centers, the I-956 form to be designated as a regional center, that fee will raise 168% from $17,795 to $47,695. This may make it more difficult to promote smaller businesses, to form more regional centers to promote newer and smaller projects to create U.S. jobs. For other forms, such as the I-45 adjustment of status application, I-131 application for travel document, and I-765 application for employment authorization, these necessary forms for EB5 investors looking to take advantage of concurrent filing to get the combo card, work permit, travel authorization in about 3 to 6 months after filing their EB5 petition will see increases between about 25 to 59%. When will this take effect? After the end of the notice and comment period, USCIS will need to review and respond to the comments and decide whether to revise the proposed rule or move forward and publish the final rule. A final rule would be published with an effective date no less than 30 days after the publication in the Federal Register. Plus, USCIS could face litigation by stakeholders attempting to block any fee increases. Now, this occurred successfully previously, where injunctions were ordered staying prior fee increases in 2020. Future litigation, successful or otherwise, would be unsurprising after a final rule is published. So in short, there's no immediate rush. The rulemaking process does take time, and even after the notice and comment period ends on March 6, 2023. Nevertheless, families considering applying for the EB-5 investor visa should not delay. New investors filing EB-5 petitions can benefit from the reserve visas, which are limited in number. So contact Barring to learn more. This fee proposal is very long, contains a lot of interesting information, some surprising, some unbelievable. So my colleague, Greg Sheehan, a former USCIS adjudicator at IPO, our CEO, Colin Barring, and I recently discussed the proposed rule on raising fees. So if you're interested in learning more, I encourage you to check out that video. As always, contact Barring if you have any questions about the Visa Bulletin or want to learn more about the EB-5 investor visa strategy to obtain your green card for you and your family. And if you found this video helpful, please give it a like. And again, be sure to subscribe so that you're notified of future videos.